So good morning once again. Thank you for joining this course and also this session. I believe you have been already learning from my colleagues on also more theoretical perspectives and also on practical perspectives in respect of the European Arrest Warrant from the perspective of other practitioners. So now I will try to give you an overview of some practical issues faced by the defense in these type of cases. So let me see if I can move. Yes, so I chose some topics, and under the heading Dual Defense in Practice, I will start with a very short introduction of what is actually meant by dual defense. And then I will touch 5 different topics and raise some practical issues in the operation of dual defense under these topics. What is dual defense? And I mean, I'm sure you've heard about this. If you haven't heard, then you have not heard any of the ERA conferences with interventions by the defense. But it is basically self-explanatory. So in a domestic criminal case, there is, of course, one defense team, normally based in a single country, in the EU case, a single EU member state. However, in cases with some cross-border link, be it what we would call traditionally a domestic case, let's say, in Portugal, we have many examples of those cases involving someone who just came on holiday for a week and then was involved in a suspected criminal offense or was a victim of a criminal offense and then goes back to their country. This is still just a domestic case, but will involve gathering evidence abroad and serving documents, etc., on that person. But in the case of European arrest warrant proceedings, it is always the case that the defense should be a dual defense. I'm saying it should be, not that it is, because from a practical perspective, sometimes due to lack of awareness by criminal defense practitioners, and also due to the difficulties in finding a lawyer in another EU member state, this is not always the practice. So what should be a dual defense? Basically, it should be a team of lawyers working in the state where the person was arrested, so the executing member state. Let's give an example of Portugal, which is my home country, and a team of lawyers in the issuing member state. We can give the example of Spain, for example, which there is many EAWs in respect of Spain and Portugal. And in this case, there will not be a team of lawyers in Portugal and a team of lawyers in Spain that do not communicate. No, the team is supposed to be one team that will operate this concept of dual defense. Each team will work in the executing member state and in the issuing member state, under a different role, of course, but those 2 roles are essential, and there is a need to coordinate and to divide the tasks. As far as I'm concerned, and also this is the opinion of other academics and practitioners, one should look at this from an overall perspective to adopt an holistic approach, because otherwise the effectiveness of the rights of defense will be at stake. It is not possible to defend someone properly in a EAW case without having a lawyer in the 2 member states. I put a little note here. Sometimes there is triple defense or even more, because there may be a 3rd member state involved in this constellation. I will give further down the line the example of cases where one invokes nebis in idem, and this could happen. Let's give my case. A person was arrested in Portugal under a Spanish EAW. Let's imagine that this person would then tell me as their lawyer in Portugal, well, I've already been tried for this case in Germany. So in that case, obviously, we would need to instruct a defense counsel in Germany to help us to investigate and also to prove the fact that this person has already been tried in that country for the same facts. This is also important, in my view, for judges and prosecutors, so other stakeholders, to understand, because often the defense will have to, in the executing state, for example, try to get an additional deadline to submit certain documents, because it's this operation that should be quite swift and easy is not always easy. First, I need to find a lawyer in the issuing state, and then I need to be able to reach, to discuss with him and to obtain the needed evidence to join in my case. And also there is the linguistic barrier that sometimes hampers this communication. Therefore, it is good for the courts and the prosecutors also to have this in mind. And often the best the defense works across the borders, the easiest it is to solve the European arrest warrant case. Often, when there is this good communication and teamwork, the lawyer in the issuing state will be able to, for example, access the case files. And in the issuing state, again, it's important for the judges to understand why the person should have access to the case file at that stage. And often either to invoke a procedural defect that may lead to withdrawing the European arrest warrant, or just to show the courts that there are no reasons for issuing that warrant, and that other alternative measures could be used instead. We will go that in the next points. So I told you this is not a very easy task. How can we find a lawyer in the issuing state? And there are obviously many ways. The most obvious way is that the lawyer in the executing state has a network of lawyers and knows lawyers in different member states and will get in touch with them, and also has the necessary linguistic skills. This is not always the case because, for example, in my home country, the legally appointed, the ex officio lawyers who are appointed do not need to have a specific expertise in European arrest warrant cases. They don't even need to speak foreign language. So it may be that the colleague who is appointed does not have a network. It may be that the colleague has a network. But anyway, there is a very useful and accessible tool, which is the European Criminal Bar Association tool to find a lawyer. This is not a recommendation of lawyers, but the people who are members of the CBA may have their details on the website, and you can just click this link and then choose by country and find a lawyer. Again, this is not only relevant for defense lawyers. Obviously, the judge should not be indicating, or the prosecutor, to the person sought who is the lawyer that they should choose in any of the member states. But it should be noted that the directive 2013-48 and equally the directive 2012-13 from the EU have relevant provisions that impose some duties on the executing judicial authority and also on the issuing judicial authority in this respect. So let's see. Upon arrest, the competent authority in the executing member state should inform the person, apart from other rights, of course, but should also inform the person who was arrested pursuant to a European arrest warrant without undue delay after deprivation of liberty that this person also has the right to appoint a lawyer in the issuing state. And the directive indicates that the role of the lawyer will be to assist the lawyer in the executing state to exercise the rights of defense in the framework of the European arrest warrant proceedings. Again, if the person says, yes, I want to avail myself of this right, I want to appoint a lawyer in the issuing state, and I should do it immediately. If they don't have a lawyer yet, the executing judicial authority shall promptly inform the issuing judicial authority, and that authority should provide the requested person information to help them to appoint a lawyer in the issuing member state. Recital 46 also states that such information could be basically to give a list of lawyers or the name of lawyers on duty who can provide information and advice in these type of cases. And it could be requested from the Bar Association to draft such a list. It is important to note that, at least in practice, I haven't seen this very often, but it would be possible if the person already has a lawyer in the issuing member state, for example, a lawyer appointed ex officio, that happens many times, especially after an indictment has been brought. The issuing judicial authority could, and in my view should, from the outset, include in the EAW form the name and the contact details of the lawyer, including email and or telephone, because letters will be too slow. And alternatively, if the person does not have such a lawyer, this information mentioned here in Article 10.5 and Recital 46 could actually already be included in the EAW form from the outset. Why is this important? Because as we all know, there are short deadlines for the executing judicial authority to give a decision on the execution of the European Arrest Warrant, and also for the defense to then exercise their right to oppose to the EAW, to appeal, etc. So what is actually the meaning of this dual defense and practice? And I'll give a few examples of issues that happen quite often. I did not include one of the issues, which is the deciding on consent and on the rule of specialty, but I will give you in the end a link to a tool where it is very clear as an advice to defense lawyers that one should not advise the person to consent or to waive the specialty principle without first consulting a lawyer in the issuing state, because that lawyer will be able to indicate to the person, you know, what are the prospects, for example, of obtaining a withdrawal or an amendment of the European Arrest Warrant. So normally, not knowing more information, I would not advise a client to consent, but in practice, it is there is a very high percentage of decisions to consent, at least in my member state. And I'm quite sure they are not all undertaken after having advice from a lawyer in the issuing member state. So what is one of the topics where this coordination between the lawyers in the two member states is essential? The assessment of the validity of the European Arrest Warrant itself, and on the other hand, of the national domestic warrant. Examples of legal issues that can be raised in respect of those warrants. In respect of the EAW, as you know, there has been abundant case law by the Court of Justice in respect of the concept of independent judicial authority for the purposes of issuing a European arrest warrant, basically meaning that the court has found that some prosecution officers are not to be considered an independent judicial authority, and also the court has required that there must be a legal remedy before a court in the case that the warrants have not been issued by a court. So basically, this is one of the points. Let's say if I am instructed to defend a client in Portugal on the basis of a European arrest warrant issued in a different member state, I'd obviously have to consult the case law of the Court of Justice, and then to consult with a colleague in the issuing member state in case this is not clear enough, to find out whether the warrant was issued by an authority that fulfills the requirements of the Court of Justice. If that's not the case, this is an issue that can be raised actually both in the executing member state, because one can raise this lack of independence or the lack of the needed features, and this may lead to a discharge of the European arrest warrant. But it can also be raised in the issuing member state, where the lawyer in the issuing member state can try to quash the European arrest warrant on the basis of this case law. Again, there must be a national arrest warrant, and that national arrest warrant also has certain requirements under EU law. It's an autonomous concept of EU law. So let's imagine we have a warrant to the national arrest warrant would be a warrant to arrests a witness, for example, because she failed to attend in court, normally that would not fall under the concept of a national arrest warrant that is acceptable to be on the basis of a European arrest warrant. We will not discuss the details of the cases, but I've put here the links to the cases, so when you receive this PowerPoint, you'll be able also to find them easily. Finally, there must be a separate domestic warrant apart from the EAW, so we have to assess these two separately. Is there a national arrest warrant? That's the first question. And then, is that warrant valid? Because if it's not valid, then its lack of validity will affect the validity of the European arrest warrant. One example that is easy to understand is the case of statute of limitation. In many civil jurisdictions, the passage of time will mean that a case can no longer be prosecuted, and therefore, obviously, there is no arrest, no detention possible in such a case. One case example from my jurisdiction, and apologies for referring to Portugal too many times maybe, but this is where I come from, and obviously then most of the experience will relate to Portugal mainly. One example, this was a very old case. It had happened in August 1995. The offenses were passing counterfeit currency and swindling. They carried a maximum of 5-year sentence, and swindling a maximum of 3 years, but the amount was 100 pounds at the time. And this was not a case where in practice someone would get jail time if they were convicted. That was the reason why the accused persons, when caught in the act in the very beginning in 1995, were not subject to pretrial detention and of course returned to their countries. They both lived in the UK. They were UK nationals. The case went on for many years for all different types of reasons that I will not refer here. But in 2008, it came to the arrest of Miss X at the Munich airport, returning from holidays from the Greek islands, if I recall well. And Mr. Y, the other accused, was also present, but there was no European arrest warrant in his respect, simply a request to find his whereabouts. What happened in this case, and the person was detained during 13 days. Why? Because in the issuing state, we argued first that the European arrest warrant was unlawful because it was disproportionate, in the sense that in the meantime it was not even possible to subject this person to pretrial detention, and it was also not, the requirements were not met in the specific case. And the second problem was that the case was subject to statute of limitation. Later on, the court declared that the case were to be closed because of statute of limitation. The EAW was withdrawn and the person ended up being released, and later on lodged a compensation claim for unlawful detention in Portugal, which ended with a settlement before the European Court of Human Rights. It's quite an interesting case, although there was no ruling on the merits. So if you're interested, please check these links. As I referred in this first case example, there is these cases of strict problem of illegality of the warrant because it was passed out of time against the wrong person, etc. But there may be cases of proportionality where the problem lies with the fact that the issuing judicial authority could have used alternatives to the issuing of a European arrest warrant. And the most important being the mutual legal assistance request, for example, for serving documents, for serving the indictment, a summons to appear in court, and also the European investigation order. I did not put here, but another example could also be the European supervision order, which is an instrument that it's very difficult to use and therefore quite underused so far. I will give you another case example. This was a case between, again, Spain and Portugal. And in this case, the Spanish authorities issued multiple European arrest warrants against different persons. They all had different outcomes. Just to give you an example of two Portuguese citizens who were arrested in Portugal, At the time of their arrest, they were put in, firstly, not in pretrial detention, but in the first 48 hours while waiting for their hearing by the Court of Appeal. They were summoned by an MLA request to appear in Spain voluntarily. So within the exact same case. It was very interesting because the prosecution office that was executing this MLA request called the defense lawyer, because there was also a case for the same facts pending in Portugal, so they knew exactly who the defendants and the defense lawyer was, and asking, where can they find the clients to summon them? And then the lawyer stated, well, they're in prison on the basis of a European arrest warrant issued in Spain in the same case. During this case, the defense tried to then ask for the Spanish authorities to conduct an interview of these persons, if these were two separate cases, by means of a video link, which could have permitted the Spanish authorities, the issuing judicial authority, to decide on whether it was worth it to maintain the European arrest warrant or just to withdraw it and impose other measures that were less restrictive of the person's liberty. This was refused. And also, in the end of the case, for your information, one of the persons was surrendered. The case was dealt with by different judges, and the other person was not surrendered. The refusal ground was nebis in idem due to a pending case in Portugal. It was an optional refusal ground. The person who was surrendered was for a long time in pretrial detention in Spain until then he was released and went back to Portugal. The case is still not finally disposed of, to the extent of my knowledge. So this raises a very interesting problem. So the first is that the defense, obviously, when working across the borders, immediately tries to, both in the executing state and in the issuing state, to arrange for alternatives to detention, to try to get bail, to try to organize an interview of the suspect, if this is an EAW for criminal prosecution, and then to convince the issuing judicial authority to impose lesser measures. The problem is that the EIO especially is quite underused. So often we see in practice that the authorities could have issued an EIO for an interrogation of the suspect, and then thereafter perhaps to decide whether they would need to impose coercive measures. This could also be done simultaneously with the European supervision order, but this was not done. I leave the question here for you, and I know the European Commission has already verified this problem. Articles 18(1)(a) and 19 of the framework decision on the European arrest warrant are underused in practice. What do these provisions say? Article 18 states that actually when a European arrest warrant is issued or has been issued for the purpose of conducting a criminal prosecution, the executing judicial authority must agree that the person is heard according to Article 19, or transfer the person. That is way too cumbersome in most of the cases. But Article 19 then says that the requested person shall be heard by a judicial authority assisted by another person designated according to the law of the member state of the requesting court, and it will be heard, let's say, for the purposes of the case in the issuing state. I think the idea behind this article was quite obvious. Once you arrest someone on the basis of a European arrest warrant, just like in a domestic case, you should interview the person and confirm or change the situation of detention. This happens in our daily practice. I recommend you to read this statement of principles. It will be put also on the folder that you will have access to. And this also talks about the how to coordinate video conferencing and European arrest warrant proceedings. Refusal grounds on nebis in idem. This is also, as I explained right at the beginning, in a refusal grounds in respect of which it is indispensable to use this coordination between lawyers in the executing and in the issuing member states, and eventually in other member states or even in third states. Nebis in idem, proceedings for the same facts, may be relevant if there is a final decision according to the concept of the Schengen Convention and Article 50 of the Charter in an EU member state. I put you here the link for some important decisions. This could be a decision taken by the executing member state or other member states, but also a decision even taken in the same, the issuing member state. But the criteria then to analyze whether the decision covers the same facts may not be entirely coincident. In terms of pending proceedings in another EU member state may be an obstacle to surrender, at least when they are pending in the executing member state. In my view, also when they are pending in other member states, but this is an optional refusal ground. And finally, there is some circumstances where the fact that the prosecution decided not to open a case or close the case in a situation that would not fall under Article 54 of the Schengen Convention may still give rise to an optional refusal ground. The obvious example is someone has been convicted, let's say, in the executing member state, but the sentence is not yet served, but the court may decide still to exercise an optional refusal to surrender, even if under Article 54 there is no mandatory refusal ground, because that would require that the sentence has already been served or can no longer be served, just to simplify things. Also, there is the possibility of raising nebis in idem in respect of a decision in a third state outside of the EU. Of course, what's the practical problem, to avoid the theoretical explanation, is how to raise this and how to prove it. So obviously, how to raise this should be raised as soon as possible by the defense in the executing state, but it may also be necessary to ask for the court to give appropriate deadlines to submit the relevant documents, and the documents may be submitted by the lawyer in the executing state. Obviously, he will need the lawyer in the issuing state or the other member state to gather duly certified papers. And normally, I would ask, of course, also those lawyers to make a short explanation on why there is nebis in idem and what's the type of decision at stake. And then there is, of course, the option for the court in the executing member state, the option and obligation, I would say, to then ask for information from that member state that issued the decision to confirm whether that decision is actually in line with the requirements of the relevant refusal grounds. I put here the different alternatives. We don't have to go through all of them. Human rights refusals, I think you have discussed this in previous sessions. I just put some examples here. This is not an exhaustive list, but again, I would like to raise the practical issues for the defense. And here, the practical issues are how to raise it and how to prove it. Again, we know that the defense has to raise it as soon as possible, and the defense has to be able to bring at least a prima facie case, let's say, to convince the court that there is sufficient reasons to believe that there would be, this is, I'm generalizing, but a general risk of deficiencies in the issuing state in respect of judicial protection. This is one example, or detention conditions, health, etc., the risks that I referred to above, and then how this will apply specifically to the person whose surrender is sought. How to prove it? This can be proven then by different manners, to get expert reports by experts from the relevant member states or international experts. These can also be heard as witnesses, although in some jurisdictions this rarely happens or never happens, but in many jurisdictions this will be the case. You can also use reports by NGOs, by intergovernmental bodies, let's say the CPT, UN bodies, and so on. Further information available that you can find in open sources, court decisions by other member states that have already identified these risks, and even other courts, and obviously the Court of Justice in the first instance, and the European Court of Human Rights. What will happen if you can raise the case to a sufficient degree of probability of this risk? Then it will be the obligation of the court in the executing state to seek assurances by the issuing judicial authority that this risk will not materialize in the situation of the person sought. And then there is a big discussion about how effective these assurances are, and how can you rebut them, and whether there can be an inspection. Some member states also use experts to do an inspection on site, for example, in a prison, to assess whether the assurances can actually meet the expectations. I left an example here. We will not go into detail, but this is an interesting case, the Catalan case, where the court reiterates some of the relevant principles. Basically, the court states that normally you cannot refuse a European arrest warrant if the ground of refusal is not listed in the framework decision. So if you create in your domestic law an additional ground of refusal, you cannot apply it. However, if that additional ground of refusal is connected with the protection of a fundamental right that is established in EU law, it is possible to refuse surrender. Then the court goes on to establish the requisites for this specific case. It is interesting from a practical viewpoint that the court also said something about the evidence that can be used. For example, in this case, there was a matter on whether there was a lack of jurisdiction by the issuing judicial authority that would be so manifest that it could violate the right to a fair trial and to be tried by an independent tribunal, and whether that jurisdiction could actually be challenged in the issuing judicial authority also before such a court. The court stated two interesting points. One was that the fact that the person was challenging this in the issuing state was not enough, was not decisive. The second was by reference to a report of the working group of the United Nations on arbitrary detention. The court said this could be a relevant piece of evidence. If it were a general report that did not address the situation of that particular person, it would not in itself be decisive. However, it would be one of the elements to be considered together with the other elements. In any event, before a refusal of this sort happening, the executing authority will have to request for further information. My final point is how does the dual defense operate after there was a final decision? Does it end? Does it continue? And I again say it should continue, but in practice it's often very difficult. For example, if the person had a legal aid in the executing state, normally that will cease to exist after surrender, and it is very difficult to follow up. I would like to give you an example of 3 topics. The first is specialty. Specialty, I think you all know the concept. So if a person has been surrendered on the basis of a European arrest warrant, the issuing state cannot subject that person to a case for a different crime that was committed before surrender. I'm simplifying, it's an oversimplification, because the framework decision establishes a list of exceptions. Generally speaking, these exceptions will apply if the person will not be deprived of the liberty in that other case. The court has dealt with this in a case already long ago, case C38808. And basically, the court said that if no measure restricting liberty is applied, then the case can continue. Please beware that restricting liberty is not depriving of liberty. So any measure, it's of course the difference is of degree and intensity. It's not yes or no, black or white, but still one will have to assess in each case whether there are measures of this nature, because if there are, then there is a bar. Specialty will apply, which means that the issuing judicial authority that obtained the surrender of a person will have to ask the executing judicial authority to provide a consent to proceed for those further offenses. What are the practical problems? There are many practical problems. Sometimes as defense lawyers, so you're acting in the issuing state in that other case, but you have no idea that the person has been surrendered upon a European arrest warrant in a different case. The person may not even tell you because they don't know whether that's relevant. So this is basically a part of the questions that a defense lawyer needs to put to their clients, if they've been extradited from another country, and then to pursue further to see if specialty applies. There is also the issue of cumulative sentences. This is a very tricky issue, but sometimes specialty also prevents the fact that you will be subject to a joinder of sentences in the issuing state for different crimes. This is something that happens in many jurisdictions, and often you will need the consent of the executing state to be able to do so. This is also very important for the defense, because often the joinder of sentences is the best for the person. So that's why from the beginning, it's very important to have this connection between the lawyers in the executing and issuing state, because it may be of an advantage to the person to actually waive specialty at some point to obtain a joinder of sentences. Finally, the person has to be heard. There is some interesting case law, and normally there must be the possibility to appeal against a decision to consent. Second problem, and I'm almost finishing, is taking into account detention periods. Let's imagine my client was arrested in Portugal. He then went off to Spain upon that European Arrest Warrant issued in Spain, and then the Spanish court will have to deduct periods of detention during the execution of the European Arrest Warrant. The first question is, the framework decision only refers to deducting detention in the custodial sentence or detention order. Let's say after the case is final, if the person was convicted, you will have to deduct the period of detention. There is no mention of a deduction in the deadline of pretrial detention itself. Therefore, there is a question, a legal issue, on whether by a matter of principle, due to the principle of proportionality, whether it is possible not to deduct those periods from the maximum deadlines of pretrial detention. I will give the example of two countries that operate differently. Portugal, the case law so far of the Supreme Court has been that the period of detention in the executing state, in the reverse situation, let's say Spain surrendered to Portugal, will not be taken into account to determine the maximum period of pretrial detention to be imposed in Portugal. This means that a person that was surrendered from Spain to Portugal may be longer in pretrial detention than a person who was just arrested in Portugal and stayed there in pretrial detention. This may raise, obviously, issues of proportionality and even legality of pretrial detention. But so far, this is the position of our Supreme Court. It's a good matter for a preliminary ruling, actually. I can say that, for example, Italy, and I think other member states don't do this. So they will, let's say, mutually recognize and deduct the period of detention suffered during the execution of an EAW in another member state, also in the maximum deadline of pretrial detention. Again, this is very important, and this is for defense lawyers to check, and if this doesn't happen, to make the necessary applications. At the end, after a state decides to surrender a person, if the executing judicial authority, after the decision, needs to provide the issuing judicial authority, either directly or via the central authority, with the information of the detention periods that have been suffered by the person who was surrendered. This is extremely important. Also, there is an interesting question, which is, what is actually detention? What are periods of detention? Does this include only prison, let's say deprivation of liberty in a prison facility, or could this include other measures? The court has already ruled on this, and it has stated that it could be other measures, and it's up to the issuing judicial authority to assess the measures that were adopted in the executing state, and to consider whether they should be treated in the same way as a deprivation of liberty and therefore are detention. There was a case that concerned a 9-hour daily curfew monitored by a tag, by an electronic bracelet, and the court said, in principle, this could not be enough to amount to depriving a person of their liberty. However, the court also stated that this is just a minimum level of protection. The courts in the member states may go beyond this. I will give a practical example. Now it's no longer a European arrest warrant, it's a TCAW, but this happened in many cases. This type of curfew imposed in the UK, and the curfew in the UK will be deducted from any sentence to be served in the UK if it's above, I believe, 8 or 9 hours. So if it's under 9 hours or 8 hours, they will not deduct it from the sentence. If it is above that period, it will be deducted, and I think it's half day from the sentence. A person that has been surrendered from the UK to Portugal, in my view, should definitely have the right to that deduction, at least, let's say, the same that would happen if they were to go to prison in the executing state. An additional issue is whether we would even need to go beyond, because in Portugal, home detention with electronic monitoring may be discounted from the has to be discounted from the prison time, and it will be 1 day, 1 day. Of course, that one may then try to rule whether this is exactly the same measure, or if it is not, whether the discount would have to be an equitable discount rather than a full discount. But again, this is an interesting question to be debated in court and raised by the defense. The last topic to finish is the mutual recognition of refusal decisions. So after surrender, it could be, one state decides to surrender extradition or EAW. What happens after that? Can the person continue to be subject to new arrest and detention in the same executing member state or in a different executing member state? Here are 3 case studies. You can check them if you would like to. I think it's quite interesting to read the statement of on mutual recognition of extradition decisions made by the ECBA. This would apply both to European arrest warrant and extradition. And there we try to distinguish different types of refusal grounds. If the refusal was a refusal due to a legal issue only applicable in the executing member state, this type of refusal will not have any effect in other member states. Let's say statute of limitation, according to Portuguese law, does not bind the other member states because this is not has not been harmonized and it's different in each and every member state. However, for example, if Portugal would refuse surrender, stating that the person has already been tried, let's say, in Spain for the same facts, so that the EU, European Union, nebis in idem, established in Article 50 of the Charter and Article 54 of the Schengen implementing agreement, then this type of refusal ground should be recognized in other member states, because it's a refusal ground based on EU law and not on the domestic law. We call this a permanent reason for refusal, because nebis in idem normally would apply forever. In cases where there is a risk of violation of fundamental rights, but this could change, let's say detention conditions, they could improve, or the problems with the independence of the judiciary, this should be recognized by the other member states unless there has been a change in those states to remediate the risk. We also propose that there is a mechanism to be able to make this work in practice. This is not just an argument made by the ECBA, it is based on a decision of the Court of Justice on WS and other principles, but I invite you also to read this document that will be put in your materials. Finally, the last point is a connected point, which is what are the consequences of a refusal to surrender for the issuing states? This appeared in the case also of the Catalan politicians. And the question, it has happened in other cases already also. So let's say Portugal issues a European arrest warrant. Germany refuses the execution. Is the Portuguese authority able to issue another European arrest warrant against the same person in the same case or not? The court has already addressed this. It has said that in principle, it is possible to issue a new European arrest warrant, but this issuance cannot result in an infringement of Article 1, paragraph 3 of the framework decision, meaning on a violation of the fundamental rights of the requested person. And one has to assess whether the EAW is proportionate, whether issuing a new EAW which should be done by the issuing judicial authority. And I leave here some of the criteria for you to check more in detail. Again, issues for the courts and for the defense lawyers to raise in their cases in case there is multiple or successive European arrest warrants. I hope I did not speak too fast, and I hope it was everything was clear. I am available to answer any questions, and I left here also for you to check useful tools. Handbook on how to defend the European arrest warrant case. It's free of charge. You can use it online. There is also a HTML version also working on iPhones and other phones. There is also a very short document which is called the defense checklist. So basically, if you are a defense lawyer, you never had a case of a European arrest warrant and you face one, this may be very useful because it will indicate to you what type of questions you should put to the client in your first consultation and so on. This has also been translated into all EU languages. So it is available in all EU languages. So this is it. If you are also interested in the activities of the ECDA, please join us. It's a very lively association. And one of the aims is precisely to get to know lawyers in other EU member states that we can call when we are faced with European arrest warrant cases. Thank you very much for your attention.